communicating together. We are all working on the same risk assessment and risk analysis framework, but we all have specific particularities. If we take a look to the regulatory framework, because we have a lot of regulations, they are all interconnected. Our model regulation, it's the General Food Law Regulation, is 178/2002. We have also the basic regulation, which is the Feed Hygiene Regulation, is 183/2005. This regulation provides all the measures for the manufacturers to ensure the hygiene of the products. So this is a basic regulation that has to be followed by all manufacturers in Europe. So it provides measures on how to avoid contamination, how to clean the equipment, for example, for mixing or for storage or for transportation. So this is, and there are also some HACCP measures there. So this is the first regulation that all manufacturers in Europe, they have to follow to ensure minimum hygiene requirements. Then we complicate the situation, and then we start making small divisions between all the feed additives and feed materials. We have the feed material regulation. This one is a quite new regulation. It's the 767/2009 on the placing on the market and the use of feed. And the first premise of this regulation, it is clear in Europe, is that feed may only be placed on the market and used if it is safe and does not have a direct adverse effect on the environment or animal welfare. So we can put only products that are safe in the market. We have, in the case of feed additives, the opportunity to use mycotoxin decontaminants. There is a new category on mycotoxin detoxifiers. However, according to the regulation, we can use these mycotoxin detoxifiers only in feed that contain lower levels than the one accepted in the regulation. So it is not the aim of this category of feed additives is not to decontaminate a contaminated product. The aim is to reduce the contamination of a product that is already okay, that is already considered safe under the European conditions. It was a new category, it was something new. It is still not very clear the use because it is to reduce more than the level of mycotoxin in a product that is safe, but we have this opportunity in Europe also. Feed should be placed only when it's safe. In the case of feed materials, there is no pre-market authorization. So how the Commission has been managing this, we have what we call a positive list. So we have a list in the register of feed materials where this is an inventory of all the products that can be placed on the market that are considered to be safe. So in this here we have soya, we have maize, we have the initial feed material, let's say. We have also another initiative from the industry, which is the catalog of feed materials, in which also we have some products that are expected to be placed at some point in the register of feed materials, which is the official one. Under the regulation 767, we have the possibility to make claims. And in the case of claims under regulation 767, there is a possibility to make a scientific substantiation of a claim. So in this case, we have, for example, the leaves of solanum. We have this claim, the use of the leaves of solanum as a source of 25-OHD3. So we receive, normally the member states can analyze and they can decide on their own. When there are some specific issues, EFSA is consulted. So in the case of this claim, the use of solanum leaves as a source of 25-OHD3, we are in the process of making the assessment of this. We use data that is publicly available, and we have sometimes documented research data from the company. EFSA is consulted only in cases where the Commission and the member states have not the possibility to decide. So for the time being, we have only one product, but the Commission and the member states have been decided on many of those products. This is the feed materials. The degree of assessment is quite different compared to a feed additive. For a feed material, so we have the positive list, and they have only a substantiation. That's all. The other regulation, which is the feed additives, it is much more strict. So we have the guidelines. We have the guidelines, which is in the regulation 429/2008. This is our, let's say, daily work is this regulation. And we have different guidance documents. So EFSA has produced guidance documents to explain the regulation. So I hope that it helps also. The other model regulation that we have is the regulation 1831/2003, in which we have all the rules for placing on the market the feed additives. So here it is stated clearly that for feed additives, we need a pre-market authorization. So all products that are going to be in the European market need an authorization. A precondition of this 1831 is that the contact person should be placed in Europe. So in some cases when we have applicants, for example, from India or from China, what they have to do is to identify a contact person, a consultant, or if they have an office in Europe, in any of the member states, this can be the contact person. So we need a person in Europe. But then products can come from different places in the world, provided, of course, that they will follow what is written in the regulation and in the guidance. So precondition, someone in Europe. Then Regulation 1831 will have also defined what is a feed additive and the categories and the different functional groups. It defines also the conditions for the authorization. Then we have for new products, for reevaluation of products, for the renewal, that we will see them during the day. It provides for the evaluation that EFSA will do to those products. So all the process that we are doing. Provide for the reevaluation, and we have time-limited authorizations, which is the difference compared to the previous regulatory framework. So we have a 10-year period authorization. Feed additives, we have different types of feed additives. We have, for example, the technological, sensory, we have the coloring agents or the flavorings, we have nutritional, we have the zootechnical. In this group, we have different enzymes, microorganisms, which are placed in a group, for example, that is called gut flora stabilizer. And the last one is the coccidiostat and histomonostat. How we are doing the assessment? So as I said before, we follow Regulation 429, which is guidelines. Guidelines is a legally binding document. EFSA has produced different guidance documents. These are not legally binding documents to the industry, but of course, they provide support. They tell you how to do the studies. For example, in the guidelines, it is stated we need homogeneity data. And then, well, we need how we are going to measure that this is homogeneously distributed or not. So in the guidance, we say, okay, you can do it in 10 different samples of the same batch. So all of these indications are provided in the guidance, and the aim are to help the applicants to see how to prepare the dossier. At the same time, the guidelines and the guidance tell us the industry and the stakeholders how the panel is going to evaluate the substance. So we know that if we ask 10 samples in the same batch, we know that the panel is going to be happy having the data of 10 samples of the same batch, and they are not going to ask something different. except, of course, if there is any problem in the case of toxicity. But then the rules are clear, the rules for the applicants and the rules for the experts. So we treat everyone in the same way. The panel, as we said before, deals with questions on the safety for the animal, user or worker, consumer, environment, and with the efficacy. We will come back to the FIDA panel in my second presentation. Then we have also the contaminants. In the case of contaminants, well, we have the content panel, with whom we work also quite closely. Because in the contaminants, they will work with all of the contaminants, and then this will be translated into in this case, we have Directive 2002/32 on undesirable substances. So when we analyze a dossier, we have to be sure that the dossier, the product to be placed on the market, complies with this regulation. So complies, it means that we have lower levels of all of these substances in the final product to be placed on the market. We have inorganic contaminants, we have levels for different mycotoxins, we have dioxins and PCBs, and here in this regulation we have also levels for authorized feed additives in non-target animals. So, for example, we know that the coccidios that are for poultry, in case of a carryover, the contaminant regulation and the contaminant panel, they are going to evaluate which could be the level that can be tolerated in a case of a carryover. So you see, they are all well interconnected. Particular example, we have here the guidance values set for some of the mycotoxins. So kratoxin A, seralanon, we have to comply in each of the dossier with this maximum level. So we ensure that the product to be placed on the market is safe. And we have the rules and we have the limits. So rules are there, they are clear, they are transparent, they are accessible to all. The content panel, so it deals with food and feed contaminants, so those substances that are not going to be dealt by any other panel. It's a very pragmatic approach. There is, let's say, nothing scientific. Pragmatic, so we know who's doing what and who will be responsible for which opinion when we receive a mandate from the European Commission. Opinions from the feed contaminant, from the content panel. We have here, I'm focusing on the mycotoxins. For example, we have the nivalenol, which is a toxin produced by Fusarium. In this case, we have enough data, occurrence data. We could set, or the panel could set a tolerable daily intake. So, and we can set a maximum limit. In some other cases, like the estrigmatocystine, we do not have enough data. In this case, the panel, say we need more data in order to be able to set limits. So you see, we have to work, in the case of a contaminant, with the data available. So with publications or with occurrence data, which also is a big difference with the feed additive, with the dossier. Because in a dossier, we have an applicant behind, and we will need data, we will ask data to the applicant. It doesn't mean that we are going to ask data forever, because at some point we have to decide, we have to conclude. And in the panel, we always have this discussion that sometimes it is nice to have some data. It is nice to know more. It is nice to have an extra study. It is nice to ask for a full data set. But okay, here we have to take a decision. And we need to ask for the data that is really needed, because this is also a burden for the industry. To produce a study, it costs. It's an investment. So we are not going to ask just for data that is nice to have, but we will ask for data that we need to have to reach a conclusion. Some previous opinions on feed contaminants. I think they are all available in our website. They are extremely interesting because they provide a framework or a general background of the information that we have, and we set the different limits, which are going to be translated later into the regulation by the European Commission. We have some of the current work here. This is just for your information. Again, more on mycotoxins and the risk for animal and public health. The other panel that is dealing with biological hazards. So we have the biohazard panel. In the case of the biohazard panel, and for your information, we have EFSA has published an opinion on the microbiological risk for feeding stuff. It's an opinion from 2008. It's quite comprehensive, and well, it brings to our attention that the main biological risk for feeding stuff is Salmonella. Then we have Campylobacter or Listeria or E. coli. But this is the role of the biohazard panel. They are also the key drivers in BSE and TCE in EFSA. And the last panel that is dealing also with feed, and with whom we work also extremely closely because they also produce guidance, is the GMO panel. And the GMO panel is dealing with genetically modified organisms in food and feed. In the case of feed additives, we know that there are an important number of amino acids or vitamins produced with the GMM. So we have a close interaction with the GMO panel in order to make the assessment. What do we assess? Well, we assess the molecular characterization of the product, in case of the feed, with compositional, nutritional, and agronomic characteristics of the product, and the toxicity and allergenicity of the GM product. A particularity of the feed additives regulation in relation with GM products is that when the Commission will make the authorization, this authorization will be linked, for example, we say valine produced with Corynebacterium glutamicum and the number of the strain. So it's always linked with the producer organism. And this is a particular case of the GMO. Those are the panels dealing with the general feed safety. For the time being, I'm going to give the floor to Gudrun, so she will continue with a little bit things on the feed additives, and I will come later with more information on the feed additives risk assessment with a little bit more detail. With this one, I just finished this presentation. Thank you very much.
I'm sorry I speak Thai จริงๆ organizer บอกให้ผมสรุปเป็นภาษาอังกฤษผมคิดแล้วผมจะปฏิวัติโอเคปะเนาะแต่คิดว่ามีการแปลอยู่แล้วถูกไหมครับพอจะได้ไอเดียด้วยถูกไหมครับได้ไหมเขาก็เป็นการอารัมภบทเท่านั้นเองว่าบทบาทหน้าที่ของ EFSA เป็นอย่างไรบ้างนะครับแล้วก็คอนเซิร์นจุดตรงไหนบ้างใช่ไหมดร.เห็นดร.มองหน้าผมก็เลยงง นะครับเพราะฉะนั้นผมก็เลยบอกว่าผมจะสรุปอย่างนี้นะเอาดีไหมแล้วเดี๋ยวเขาบอกว่าถ้าผมพูดไทยเขาจะแปลเป็นภาษาอังกฤษให้ด้วยใครที่ไม่ได้ผมก็เลยงงแล้วเชิญผมมาทำอะไรก็ไม่รู้ แต่ว่ามีหน้าที่คือมาเชิญแนะนำสปีกเกอร์โอเคไหมครับครับเพื่อไม่เสียเวลาเนาะin order to rush I mean the program according to we late almost 15 minutes so the next speaker she is Dr. Gudrun Kaufhof. She was born in Germany, Duisburg, right? Yeah, she graduated from Hanover Veterinary University. I think everybody that are veterinarian in Thailand also know Hanover University, right? According to our lecturer, graduated from there a lot. She graduated from 1985. And she got a doctorate from the same university in 1986. So she worked in Germany as a veterinary practitioner, a state laboratory, the Federal Ministry of Health and Laboratory and Consultancy of Enterprise. In 1996, she joined European Commission And has since then, she worked in the field of medicinal products, food and feed law, EU enlargement, animal health and welfare. Dr. Karlhoff obtained a Bachelor of Law and Master of Law as well, degree via the distance learning from British University, and currently work in the Legal Affairs Unit of Directorate, General Health and Consumer. So, ladies and gentlemen, please welcome Dr. Karlhoff.
Hello, good morning. Thank you for this kind introduction. As you have seen, I started to be a veterinarian, and I'm now more in the legal affairs. Sometimes you don't, if you work in an organization which is dealing with legal, mostly legal rules and so on, you don't want to start every sentence with, I'm not a lawyer, but.
Yeah. Well, anyway, you graduate from lawyer, a master degree. Eh?
So you get tired of that one time, and then you just do the legal studies as well. And I find the veterinary studies, because it's so much of all practical, it's much more difficult, isn't it? So I will today speak about the feed additives definitions, and also I understand that some of you have difficulties to understand why we ended up with that legislation as it is. And of course, it's something different if you start one day and you think I'm going to draft now the perfect feed additive legislation from scratch. This, in Europe, we didn't have that situation. We started out with 6 member states in the beginning who had already some idea of how this kind of area would be regulated, partly not. And so we never started out from scratch. We always started out with something that we already had. And this you can find in the legislation, that things developed over the years. And those who've been here yesterday will probably already appreciated that we have gone through waves of reform in Europe, not only on feed additives but also on food labeling and food additives. And this shows in the legislation as it is. So sometimes we have pieces that don't really fit together. And that's, we started out in one area, and then found out that creates problems in another area. Then we started to regulate that, and that then led to more things to adjust in yet another area. And feed has always been a problem area. It has been associated with a number of, inverted commas, scandals. There's always a temptation to use as feed something that you would normally throw away. Because there's also in Europe, I guess here it's the same, there's always a lot of pressure on agriculture to produce more cheaper than before. There's also, the clients are silent, they don't say any much what they get fed to, so the pigs and the poultry, they're often in cages, they don't have the choice, they cannot wander around and look for the best food that they can get, like humans. They can go to that supermarket, and if it has bad food, then nobody goes there anymore and it will disappear from the market. So there's always been a temptation to use as feed some things which are maybe not as appropriate, to cut corners, to use a proverb. And that shows also in the legislation, and that makes it sometimes difficult to understand where it ended up if you don't appreciate that history of the legislation. So in Europe, feed was one of the things that had been tackled very early on. So already we had the first directive in 1970s, And as you can see from the definitions, the definition over the time has changed. And that legislation from the 1970s has been changed time and again. Claudia estimated over 250 times. I haven't really counted it either. I only remember when I joined the Commission in 1996, I wasn't aware of that legislation, only partly. We had only, in Germany at the university, we only looked at the German legislation, and we talked about that yesterday, that we had directives in the beginning which were taking European agreements, but were putting them into national law. So if you studied, like me, veterinary medicine in Germany, you would only see the German law. And you would have to put some effort into finding out where it was European harmonization and where it was not. So from the national perspective, if you're not interested or not working in Europe, you wouldn't know what was European harmonization and what was German law. And of course, this also created difficulties over the time, because other member states like Italy at the time or the Netherlands, they would maybe not 100% use the same means of interpreting it. Somebody asked yesterday, what is the difference between a regulation and a directive? And that's basically it. A directive has to be implemented to arrive at a certain goal which is described in the directive. So every member state has a choice of how to do that. Somebody might do it in a law, somebody might rather be relying on legislation based on a basic law. Some things might also only be reached by just implementing it via the control services. So also that led over the time to differences between the laws of the member states. And you can imagine in the beginning we had 6 member states. You went to Brussels and there were 6 people you had to talk to, and one person from the council who would moderate that. And I mean, among 6 people, it's not so difficult to find a compromise. But now, it has changed already over the time that I have been in Brussels, and that is not since the beginning. We have more and more people sitting around the table, and as you know, we have now, with Croatia recently, 28 member states. So if you sit around the table with 28 people, plus the moderators, it's much more difficult to find a compromise. And it's much more difficult to appreciate what kind of different interpretations of certain things people have in their national law. So imagine you will one day have an Asian union here, and then you have these different people sitting around the corner, around the table, and you have to compromise with the people from Myanmar and the other people from Indonesia who have a closer look what Australia is looking. So for us, the Australia, for the Indonesians, is the UK and the United States. So you get different influences, and that has so this kind of effect you can see in our legislation, and this is also why we have come to go more into not having directives but regulations. And the difference is the text of the regulation is immediately applicable in a member state. So you don't have to transpose it, as we call that, into national legislation.